Well, hello and welcome. My name is Stephen Wood, and I'd like to welcome everybody to the webinar, Sharing the Burden, Determination of Fossil Fuel Companies' Fair Shares. I apologize for the noise in the background, which will stop momentarily. This is the third in a four-part webinar series on climate accountability litigation by governments against fossil fuel companies, exploring the options. And just as a reminder, I'm going to bring us back to the beginning of the webinar series. On November 6th, we had part one, Crossing the Threshold, which looked at threshold issues in this sort of litigation. In part two, on Monday, November 9th, 1 week ago, we had a session on connecting the dots, which was really looking at the current state of science in terms of attribution of greenhouse gas emissions to particular sources or actors. And this week, today, Monday, November 16th, 2020, we are looking at the more normative, moral or legal question of allocating responsibility in the sense of sharing the burden and determining the fair shares of responsibility of various different actors, including the major fossil fuel companies. And 1 week from today, we're going to have a final webinar putting it all together, implications for investors, lenders, insurers, markets, campaigners, and more. And I'm now going to stop sharing that screen so that you can see me, and I'll just say a couple of words of introduction. So, as I said, my name is Stephen Wood. I'm a professor at the Allard School of Law in the University of British Columbia and the director of the Center for Law and the Environment, which is one of the sponsoring organizations of this webinar series. The other sponsoring organizations are West Coast Environmental Law, the Faculty of Law at Thompson Rivers University, and the Faculty of Law at the University of Victoria, all in British Columbia. And I'm particularly grateful to Andrew Gage at West Coast Environmental Law, who has been the driving force behind this collaboration. I also want to start by acknowledging that I am at present situated as an uninvited guest on the traditional, ancestral, and unceded territory of the Coast Salish peoples, in particular the Musqueam, Tsleil-Waututh, and Squamish nations. I'm very grateful to be tolerated here as an uninvited guest. Just to let people in our audience know a few logistical points. This webinar is being recorded like the others before and the one to follow. They are available, once recorded, they are available for viewing on the website of the Center for Law and the Environment. And if you simply Google Allard Center for Law and the Environment, you should find us very easily. Format is that we're going to have presentations from our panelists for around 15 to 20 minutes each. I'll introduce each of our speakers in turn when it comes their turn. And after each presentation is finished, we will open up very briefly for a couple of minutes of questions from the audience that are aimed at clarification, specific questions about that particular presentation. And when all of the presentations are finished, we'll open up for general Q&A. We should have plenty of time for that. If things go according to schedule, we should have at least half an hour for the general Q&A. Let me just say a word about how to do the general Q&A. We are not going to use the chat function in Zoom. So please don't use it, and it won't be monitored. We are going to use the Q&A function for audience questions, and that is found in your Zoom controls, usually at the bottom of the Zoom screen, and it's called Q&A. What you can do is at any time you have a question, even during the presentations, you can type it in the Q&A. Everyone in the audience, along with the panelists, should be able to see questions as they're typed. Members of the audience can upvote particular questions. We won't pose the questions as they are typed. We'll wait until the appropriate times. I'll moderate the Q&A. So what that means is that I'll determine which questions to pose to the panelists in what order. If there is time, I will also give the questioners the opportunity to pose the questions live. That is, if I can figure out how to unmute people for that purpose. So if you'd like to pose your question live, you could just indicate that in your question when you type it. But I should say that if we're running short of time, or if I can't figure out the technology to do it, we'll have to resort to the less interactive option of me reciting the questions to the panelists. I think that is a sufficient introduction to the basic logistics. And now I want to give a brief introduction to the topic for today. And for that purpose, I'm actually going to bring us to the registration page for today. And I'll refer to this also when I introduce each of the speakers. So really, the theme that we're looking at today is if governments, including, for example, local governments who are facing substantial costs to adapt to a changing climate, or to repair damage to infrastructure that is caused by climate change, with governments, with the prospect of governments bringing legal action against fossil fuel companies for a fair share of their contribution. How do we determine that fair share? Are the fossil fuel companies on the hook for 100% of the climate costs, when clearly it is a collective problem? Everybody contributes to greenhouse gas emissions and to the problem of climate change. So what is the basis on which to determine who has done enough to cause anthropogenic climate change that they could be sued, and how those costs should be shared amongst defendants? Is there a place for the notion of contributory negligence, either by governments or by citizens? And how should governments or council contemplating or bringing actions like this respond to the objection that might be raised in the media or by defendants that this is a form of hypocrisy to be going after the fossil fuel companies? Where we're going to start actually is with one of our panelists who is not in fact able to be with us today, but who is a major figure in this field, and that is Rick Heideman, who is the founder and director of the Climate Accountability Institute. He's not available today, but I was able to sit down with him by Zoom a week or so ago to record an interview with him, and that's where we're going to start. So let me introduce Rick virtually, and then I'm going to play the video of the interview that we had. So as I mentioned, Rick Heide leads the Climate Accountability Institute, where he runs the Carbon Majors Project, which first published its findings in 2013. And the idea is tracing carbon dioxide emissions to the largest corporations that produce and market carbon fuels worldwide. So CAI, pardon me, was founded in 2011 to provide the scientific basis for leveraging climate stewardship by oil, gas, and coal producers. Richard published his thesis, A Geography of Carbon, in 1984, and has been working on championing sensible action on climate ever since. And now I'm going to attempt to show the video of my interview with Rick Heide that was recorded a week or so ago. So I will try to do that. And here we are. So I'm joined by Rick Heide, the director of the Climate Accountability Institute, and we're talking about sharing the burden, determining fossil fuel companies' fair shares. And many people are familiar with the groundbreaking work you've done, Rick, on the Carbon Majors project, which was first released in 2013 and challenged the world's obsession at that time with individual and national level greenhouse gas emissions by revealing that nearly 2/3 of anthropogenic carbon emissions since 1750 could be traced to the 90 largest fossil fuel and cement producers, most of which still operate today. So the first question I'd like to ask you, Rick, is why was it important to focus attention away from individual and state level emissions to the producers?
Thanks, Stepan. First of all, thanks for inviting me to this discussion. And the reason I focused on fossil fuel companies was that I thought the international diplomacy through UN FFCC and the COP process was a bit ponderous and slow, even though based on equitable principles such as common but differentiated responsibilities. I attached that common but differentiated responsibilities to the companies that extract, market, refine, and deliver the vast majority of carbon fuels throughout the world. And we needed to exercise some brake on their extraction rate. And in terms of them being largely in control in terms of capturing government regulators and legislation through campaign contributions and other determinants of how much carbon and fossil fuels we not only extract but deliver, we need to focus on their industry, and no one had really identified them, even though we broadly know that fossil fuel companies do the fossil fuel extraction. We needed to identify the specific companies and how much historically they have contributed to the atmospheric CO2 increase, so that we can then go back and apportion some responsibility for their share, covering both their operational emissions and the emissions from the products extracted and delivered worldwide. And the latter is the majority of their attributable emissions, according to my methodology. So they have managed to perpetuate the carbon economy, and that threatens climate stability, and some of the onus of how they have managed and control the carbon economy to increase carbon intensity and perpetuate it, they need to reduce their extraction in line with the Paris Agreement's enhanced ambition of not exceeding 1.5 degrees centigrade, and they have a strong role to play.
And is it merely their production of these fossil fuel products that gives rise to the responsibility, or is it something more than that?
Well, they have, in order to protect their profits, sought to perpetuate the legitimate extraction and marketing of fossil fuels. It's in their interest to, and in some cases even disinform the public about the impact of climate change. They have invested heavily in climate denial in order to delay legislation and action on climate change, both domestically and internationally. So both in terms of deception, not only their direct contribution to atmospheric CO2, but how they have convinced large segments of society in Canada and the US and elsewhere that climate science is undecided and up for debate and no action should be taken to curb production and emissions.
So I'd like to bring things forward in time a bit closer to today. So last year in 2019, you and the Climate Accountability Institute released a new study showing that the top 20 fossil fuel companies were alone responsible for more than a third, in fact 35% of global CO2 emissions since 1965. And as you mentioned, the vast majority of these emissions come from combustion of their products as opposed to their own direct operational emissions. So when confronted with these findings, the typical response of the fossil fuel companies is that they were not directly responsible for those emissions attributable to the combustion of those products by consumers. Those are attributable to the choices of the consumers to burn the fossil fuels. So how do you respond to that? Is it fair to place responsibility for those emissions on the producers rather than the consumers of fossil fuels?
Look, it's certainly true that we're all emitters, but that does not mean that we're equally responsible. As emitters, individuals, communities, energy using and carbon emitting companies all share some responsibility not only for the emissions, but we all have an obligation to some degree to reduce our carbon intensity of our lifestyle or our transportation or the companies that we work for or the communities that we work for. But I think the fossil fuel companies have a much larger share of the responsibility and thus accountability for climate change than individuals users are. They have made sure that the carbon intensity of national economies or regional economies remains high so they can sell more products. They're profit oriented. They're not particularly concerned about climate impacts on their own company more than the impacts of potential legislation to curb emissions. So I think the companies that have contributed the lion's share of climate altering gases have also a lion's share of responsibility for addressing the problem they helped create, not only physically in terms of the carbon they have conveyed to the atmosphere, but also morally and potentially legally.
So if sort of knowledge of the risks and continuing to pursue a course of conduct in face of that knowledge is part of the reason why there should be accountability for the producers, how does that factor into determining the sort of contributory responsibility of the consumers?
Well, consumers do not, as my friend Amory Lovins used to say, want lumps of coal or gooey oil. They want hot showers and cold beer. And so national governments or regional governments, as well as us individuals, we're a bit confused about our roles. But it's fossil fuel industry in partnership with muddle-headed governments, in my view, that have perpetuated carbon intensity, and sought to support the industry both for tax reasons as well as job reasons, without paying due attention to least cost ways to provide energy services. We don't need more oil, we need more transportation, for example, or shaft power, or renewable electricity generation. We don't need more fossil fuels, given the dangers that increasing future production of oil, gas, and coal will make life on our planet all the more dire. And the people who suffer are less often the people in our own communities than people in low-lying areas and farmers in Kenya and all kinds of civilizations and cultures that will be far more impacted than ourselves.
Yeah, so
just to conclude, you know, consumers and taxpayers have borne the cost of subsidizing fossil fuel development. And we're now being asked to also pay for climate mitigation and adaptation. And I think the adaptation cost that they have increased over time, rather than entering a national discussion early on when the climate science became clear, some 40, 50 years ago now,
yeah,
and instead invested in climate denial and obfuscation.
So that's, I think that's a really clear answer on the sort of relative accountability or responsibility of the consumers and the producers. But your answer also indicated that governments are in a bit of an ambivalent position. And this series of webinars is about the prospect of governments, especially local governments as infrastructure owners, suing the fossil fuel majors to recover a fair portion of the costs of climate damages that have already been sustained, and adaptation, especially adaptation of infrastructure to a changed climate. So I just wonder if you can say a little bit more about what position governments are in. And I mean, really, to put a sharp point on it, is it fair for local governments whose policy decisions have perhaps contributed to a kind of a low density, car-centric and carbon intensive development model, now to turn around and ask for the fossil fuel producers to pay for the damages that they're now facing?
Well, as it is now, it seems like taxpayers and citizens bear the brunt of the cost, both for climate damages as well as the actual financial cost of adaptation to these climate changes. And I agree that all segments of society share some responsibility, including local and provincial governments. But that it's my contention that the fossil fuel companies and their trade associations bear the largest share of responsibility. And it's appropriate to hold them to account. It doesn't mean that they should share or pay for the 100% of infrastructure adaptation, for example. But to this point, it's 0%. So somewhere between 100% and 0%, we need to find an equitable distribution of paying these costs. And I've never said that the fossil fuel industry bears sole responsibility for paying these adaptation costs. But we have to work out through both climate modeling and source attribution. That basically is my focus, is what are the sources of the emissions, the fossil fuel producers primarily. But there are other industries that should be included in our calculus, as well as economic modeling of the actual costs from climate change and the necessary infrastructure adaptation. We need to do some economic modeling that we haven't done much work on yet, but that should be one of the next steps. So there are other industries involved.
And just a final question, Rick. It's probably the hardest of all. Do you have any suggestions for how we determine those shares between 0 and 100 as between the producers, the governments, and the ultimate consumers?
Well, that's a difficult question to answer at this point, but there are several considerations here. In terms of source attribution, we need to consider when the clock on responsibility and accountability should start. I have tentatively put the date as of 1965 based on the oil industry's early knowledge about the potential impacts of their industry and the potential impacts of climate change on the industry itself. They had early warnings from the 1950s, possibly even earlier, about climate change and how it would impact the industry. Whereas I've only placed the clock starting in 1965, I'm sure lawyers will be discussing what's fair. It might be 1960, it might be 1980, but we know it needs to be set. And as we talked about earlier, there are other industries involved.
Yeah.
Governments are involved. We need to first have a discussion about the source attribution, which other industries contribute, whether it be forestry and timber companies. We have some partial data on that. We have better data on dairy and livestock contributions to atmospheric emissions over time. We have some knowledge of refrigerants and nitrous oxide sources, but there are other gases involved that are not related to the energy industry that we need to consider. So it becomes a pretty complicated calculus and discussion, but I think we can have that discussion over the next few months and years, for that matter, to resolve how to apportion responsibility. And we've only started that discussion, but it should be open and fair and transparent. And the views of industry that we've brought into this should also be respected and listened to.
We really appreciate your participation. So thanks very much.
And I appreciate the discussion with you, Stefan. And good luck in the webinar that I unfortunately can't attend, but keep up the good work.
Thank you very much.
Thank you.
So just a reminder, that was an interview that I recorded with Rick Heide around a week ago. And I should say that recording will be available alongside the recording of this webinar, just in case in the webinar itself, you found it choppy or otherwise hard to watch. Rick, as I mentioned, is not here with us today to answer questions, but he did send me a follow-up message after the interview, and I just want to quickly read something he said before then moving on. So he said, I should have, in one of my answers, looked to the end game, not to bankrupt companies, nor to be awarded damages by industry, which I ardently support, but that we want the industry to transform and aid the transition to a low-carbon global economy. They have the skills, resources, moral, and perhaps legal obligation to lower production and net emissions to zero by mid-century. Whether even companies that grasp the necessity to at least commit to a 1.5C pathway or well below 2C will succeed, or succumb to rent-seeking and milking assets, it's important that such commitments are made. Now it's up to us to keep their feet to the fire, also on the laggard companies, chiefly US and Canadian. And he continues, I've often said that accounting for and attributing source emissions, carbon majors, is only the beginning of attributing responsibility. Those lead to emissions and to atmospheric CO2 increase and to temperature and sea level rise. Chevron may be responsible for 3.1% of global CO2 from fossil fuel and cement sources, 1965 to 2018, but you need a climate model to quantify and reflect non-energy CO2 and CH4 and other GHG gases, deforestation, and other anthropogenic net sources, so that Chevron is attributed less than 3.1% responsibility for, say, sea level rise. And then you also have to model the economic impacts and then apportion economic damages. This work hasn't been done yet, but it seems likely that the damages curve rises steeply with increasing storm intensity. So I know that there have been a couple of possible questions for Rick. He's not here to answer them, as I said, so I'm going to need to go straight to our first live presenter. But it may be possible that we can address some of the questions that Rick might otherwise be well positioned to answer in the Q&A for the other panelists. So I'm now going to introduce our first live presenter, and that's Ben Franta. So Dr. Benjamin Franta is a JD PhD candidate at Stanford Law School and the Stanford Department of History, where he studies the history of fossil fuel companies. He has served as a consulting expert for climate lawsuits in the US and is the director of accountability research at the Climate Social Science Network, housed at Brown University. He holds a separate PhD in applied physics from Harvard and is a former research fellow at the Harvard Kennedy School of Government. Ben, thank you so much for joining us. Welcome. And I'm handing the podium over to you. So please go ahead.
Thank you very much. Thanks for having me. I'm just gonna do a presentation first. I'll share my screen. And I'm going to talk about some of the historical behavior of the fossil fuel companies that's relevant to these lawsuits. And really, there are three categories of activity that are of interest here. One is the company's internal knowledge of climate science. The second is their external communications and often disinformation about that science. And then the third is misleading portrayals of their own companies or their products. I'm just calling that greenwashing here, but it's actually quite a large category and it's legally actionable too. So I'm just going to give an example of each one, and there's a big body of research in each of these categories and more. But for internal knowledge, this is a really exemplary case. This is an internal report from Exxon in 1982, all about global warming. And here are some of the quotes from that report. It talks about potentially catastrophic effects. It talks about flooding in particular places around the country. It talks about climate-related famine and migration globally. And it contemplates the cost of adaptation, and partial adaptation, it estimates to be a few % of gross national product. And today that's about $400 billion. That's just for the United States, and that's just partial. So by 1982, Exxon's own report shows that it foresaw catastrophic impacts from its own products and knew that adapting to the changes would be quite expensive. And here's the quantitative temperature and CO2 projection in that report. And this, by the way, was not disclosed to the public. This report was only discovered within the last 5 years. So this is new information. And what you see here is Exxon's projecting how much CO2 will be in the atmosphere in what year throughout the 21st century, and how much global warming that will correspond to. And if you look at what has actually occurred, Exxon's projection is extremely accurate. I have here the amount of CO2 in the atmosphere in 2019, and I have an up arrow because we're completely ignoring methane, but if you convert that to CO2, which is not necessarily straightforward, but that is adding additional atmospheric warming effect. And then the amount of global warming, which is also just about spot on. So Exxon's projection was extremely accurate, and they held this knowledge in 1982 and other knowledge earlier, as Rick pointed out. Been some great investigations along these lines. The early knowledge of the fossil fuel companies, Exxon, the road not taken, is all about Exxon. It's very good. One of the first investigations along these lines, and then Center for International Environmental Law also has some great research they've done, and these aren't the only groups, there are others as well. And like in the tobacco case, where millions of tobacco-related documents are stored online at the University of San Francisco website, they've just put a fossil fuel section there as well. So that has over 1,000 documents that are internal documents that have been discovered in the last few years, and that's growing all the time as well. So it's a great resource for scholars or lawyers, anyone interested in this area. So the second category is external disinformation about climate science. And again, this is a huge area of research. This is just one example. And it says that climate scientists don't say that burning oil, gas, and coal is steadily warming the earth. That was in the Washington Post in 1997 in an op-ed that was written by American Petroleum Institute Executive Vice President, and the same person was the chairman of a group called the Global Climate Coalition. And although I know that sounds like an environmental organization, its actual purpose was to delay climate policy, and it's one of the more infamous industry anti-climate policy coalitions to ever exist, formed around 1989. And here's the membership list from that organization, which was only recently discovered. And you see you have the major fossil fuel companies there, but you also have lots of other companies, not just the extraction companies, but other industries that are interested in the free flow, the continued access to fossil fuels, petrochemical companies, power utilities, and so on, auto manufacturers. So there are lots of companies that are implicated in the history of disinformation, and those might be legally relevant as well. I just mentioned that was the Global Climate Coalition, and what this chart shows is many of the different policy delay coalitions to have existed from 1989 to 2015, and they still exist today. But you can see that Global Climate Coalition is just one of them from 1989 to 2002. This has about a dozen in total. This is from research by Robert Bruhl, who's done a lot of the groundbreaking research on organized climate disinformation and delay. And my point here is just that it's a very sophisticated campaign and far-reaching to delay climate policy. And some of these organizations put out quite clearly false and misleading information, whereas others were more focused on lobbying against policy more directly. And so they're not all exactly the same, but these are all relevant to the whole story of climate policy delay. And then the third category is greenwashing. And you might have seen advertisements from Exxon Mobil about its biofuels research. These are a few more from BP about its solar energy facilities, or Chevron telling the public that it's behind renewable energy. But if we look at the actual numbers, these companies are not spending a substantial amount of money in clean energy sources. This is the capital expenditures of different oil and gas companies over about a decade, from 2010 to 2018. And this is in percent. So on the horizontal axis at the bottom, you have percent of CapEx spent in these different categories. And Total is at the top of the list, but still at only about 2.7% if you exclude the energy smart technologies, which are basically efficiency. So those aren't really renewables. They don't change the market share per se of the different energy technologies. But the other companies are even less. If you look at Exxon Mobil, it's 0.2%, Chevron 0.2%. And so these advertisements that talk about all the support and money that the fossil fuel companies are putting into renewable energy, legally those are potentially misleading advertisements. because if you're spending 99.8% of your investments doing one thing, but telling the public you're doing something else, that arguably is misleading. So this is also an important category of legal action against the companies. In addition, the fossil fuel companies have been spending a huge amount of money lobbying, conventional lobbying, against climate legislation. This analysis says the companies spend 10 times what pro-climate policy groups spend. And this is again based on research by Robert Bruhl, just out a few years ago. And of course, typically lobbying is protected speech, at least in the United States, but at least according to some legal holdings, if it's intentionally deceptive, then it's not protected. This is from US v. Philip Morris, the famous RICO case in the United States. This is from the circuit court in DC that reviewed the case. And they pointed out that at least in the United States, the First Amendment doesn't protect intentionally deceptive lobbying, nor do other relevant doctrines like the Norr-Pennington Doctrine, which typically protects private groups that lobby, even if it leads to monopolistic outcomes. But in any case, if it's intentionally deceptive, then it appears it's not protected. And I don't know how much this has been tested in court in the United States, but it appears to be good law. And if there are lawyers in the audience that are practicing that know more about this, I think it would be great to hear about how important this is, or may not be, for this litigation. And just another example, especially targeting young people, promoting products like natural gas as sustainable, safe, clean, healthy. This is very, very reminiscent of what the tobacco companies did, portraying their products as healthy, safe, even using visual associations to associate them with a healthy lifestyle. And some of the lawsuits that are ongoing in the United States, they specifically point this out. This is directly from the Massachusetts Attorney General's case against Exxon Mobil, their complaint. And it points out that, the oil companies, in portraying their products as green and sustainable, is similar to how the tobacco companies misleadingly promoted low tar and light cigarettes as healthier, less harmful choice, even though they were all dangerous. And again, like this advertisement from the tobacco industry saying, considering everything I'd heard, I either wanted to quit smoking or choose this cigarette. And I decided to choose this cigarette, which was ostensibly safer. There are parallels with how the oil companies are portraying some of their products, like natural gas, for environmentally conscious consumers. All right, so those are the three pillars. And almost all the activity of the fossil fuel companies that's relevant to the litigation falls under one of these categories. Now, the last part of my talk, I just want to point out that the damages here are quite actual. They're not speculative. Infrastructure is being considered and money is being set aside now to deal with climate change. This is just one example. $600 million to build a seawall to protect one airport, just the airport near San Francisco. And this study anticipates $400 billion just for adaptation for sea level rise. That doesn't include the other impacts of climate change. So the price tag does appear to be quite large, as Exxon estimated back in 1982. The last time I checked, there are at least 16 cases of this sort against the fossil fuel companies going on so far. There might be more, I might have missed some. This is the ones that are occurring right now. And there are also congressional hearings on the issue. This is one from October of 2019. You have Naomi Oreskes from Harvard University, the historian of science, who has done a lot of research and writing on the fossil fuel companies, and Ed Garvey, a former climate scientist for Exxon Mobil, now telling the public about the research that the company did internally. So I would expect that there may be more of these, depending on how the Senate turns out, and of course there'll probably be some in the House, and so on. Now I wanted to address briefly this question of contributory negligence, because this is one of the main themes of this workshop. But these are some arguments against contributory negligence to consider. So one is that the defendants, the fossil fuel companies, they held actual and or constructive knowledge, and in most cases it was actual knowledge of the harms from their products. And despite this, they concealed their knowledge, both through failing to disclose what they knew to the public and by affirmatively disputing what others knew, what other research showed. So that is another important part of it. And your average person, despite filling up their gas tank, they're not spending millions of dollars to dispute climate science the way the fossil fuel companies did, and in some cases continue to do. They also promoted ever greater fossil fuel use despite their knowledge. And while that might not be legally actionable, and again, I'll defer to the practicing lawyers on that, that's an important part of what actually occurred historically. The companies did have a choice about what energy future they would promote, and they decided to promote one that they knew would be very dangerous for everyone on Earth. Again, they delayed outside efforts to reduce the harm through lobbying, through disinformation, and quite importantly, I think, these products were all used as intended. They weren't misused. This is not a case of a plaintiff using a product wrong and injuring themselves or something like that. They're using the product exactly as intended, as manufactured, as produced by the companies. So these are just some arguments. There are probably others for why, again, reinforcing what Rick was saying, that we all have responsibility, but our responsibilities are different, and the responsibilities of producers from a legal standpoint are quite different from those of consumers. So that's all I have for the presentation, and thanks, and look forward to the Q&A.
Stephen, you muted.
Thanks so much, Ben. We do have time, as I promised, for a couple of direct questions about your presentation, preferably aimed at clarifying points you made or expanding. If audience members have such questions, put them into the Q&A, not into the chat. I think for now, we're going to hold aside Dan Galpern's question about Rick Heady's work. But I will pause for a moment to see if there are questions directly for Ben from the audience. And they may be coming, you may be typing furiously. We don't see them until you hit enter or whatever the relevant thing is. If not, okay, so investment in greenwashing, the question from Natalie Oman. Can you say a little more about Carbon Major's investment in greenwashing?
Sure. So there are a number of subtypes of greenwashing that are relevant here. So one is to do with how the companies portray themselves as a company. And so I showed some of those advertisements of companies like Chevron saying, we're behind renewable energy. So that relates to the activities of the company as a whole. There are lots of advertisements that portray the oil and gas companies as compatible with averting severe climate change. So they portray the whole industry or the whole company as safe, healthy, sustainable. You can limit climate change, honor the Paris Agreement, and so on, while still embracing this company. Now, I think there's a very strong case to be made that those are quantitatively incompatible representations. And so that's one category of greenwashing to do with the company itself. Another one has to do with individual products. And perhaps the most important one here is natural gas. So a lot of advertisements portray natural gas as low carbon, as climate friendly, and almost all of these advertisements completely omit the methane emissions associated with gas production and use. And so that's a material omission, arguably, because that's an important part of the overall climate impact of natural gas. And so, you know, that's another example. And there are other ones to do with different products too. You know, the way the companies portray global warming itself, generally downplaying its severity, saying, well, we're out of the woods. And of course, this has been going on for many decades, essentially since it became a major public policy issue in the late 80s, although there's actual research that is forthcoming that shows that the oil and gas industry is downplaying climate change since the early 80s, even earlier in policy circles. So that might fall more under disinformation than greenwashing. But again, it's a way of implying that the industry is more sustainable than it actually is. So I hope that's helpful. And a number of different jurisdictions have statutory prohibitions against misleading and unfair business practices, and greenwashing arguably falls under that. So, and I might add actually that in some jurisdictions, and I'm thinking of European ones, some of these companies have already been sanctioned for these advertisements being essentially greenwashing, misleading, to do with promoting natural gas as clean, and just the activities of the companies being sustainable. So there's some precedent there.
Can I just invite you really briefly, Ben, to respond to Linda Nowlin's question? What do you expect from a Biden administration in terms of action to deal with the corporate deception, if anything? And then we'll have to move to Andrew.
Well, it's a really great question, and I don't know. Clearly, more action will be forthcoming, presumably, than in the previous administration. But at the same time, the Democratic Party, I think, is loath to make enemies with the oil and gas industry. We saw this with Obama's administration, that it was much easier to attack coal politically than oil and gas. And so, you know, we'll see what will happen. Well, I hesitate to speculate, but we already have seen that the oil and gas industry wants to gain immunity from these lawsuits in exchange for support for some sort of legislation. They want to essentially create a global peace settlement without an actual legal settlement, it appears. And I'm specifically thinking of this, I think it was called the Climate Leadership Council, and it was many different oil and gas companies that wanted, in exchange for support of a carbon tax, they wanted immunity from lawsuits. They also wanted the rollback of many other regulations to do with climate change. So, you know, make your own mind up regarding whether that's a good deal or not. I think it wasn't a good deal for the climate because the carbon tax was quite low, and giving away things like immunity from lawsuits, I think would be a bad deal for the climate, but make up your own mind about that. But I hope that's helpful. I have no special knowledge on that front.
Thanks so much for that, Ben, and thanks to others for the questions that are coming in. We will keep those in mind, but right now I need to move to the next speaker, Andrew Gage, who's an environmental lawyer, has been an environmental lawyer for more than 20 years and is the project lead for West Coast Environmental Law's Climate Change Program. Under Andrew's direction, the program has focused on legal and professional consequences for industry, government, and professionals of failing to address climate change. His current work focuses on helping BC communities, that is British Columbia communities, understand the climate change costs they're already facing and the role of fossil fuel economy in causing those costs. So over to you, Andrew. Thanks so much for joining us and for the role you've played in leading this entire project.
Great, thanks very much, Stephen. Thank you everyone for joining us. I'd like to start just by acknowledging that I'm presenting from the territory of the Kwungan-speaking people on the south end of what's now Vancouver Island. I often begin my presentations with a bit of a joke, saying that as a public interest environmental lawyer, I'm like a cross between David Suzuki and Perry Mason, but without the money or hair of either. It's a joke, of course, but the reality is I do have a foot in the world of environmental activism and another foot in the world of law. And so I'm going to speak to today's topic from both perspectives, first from a climate campaign perspective, and then from a legal perspective. And let's start with the truth that I think both lawyers and campaigners should recognize, which is that the reason why this discussion about the fair share of the oil and gas industry and the fossil fuel industry rather matters is because society has largely separated the benefits of the fossil fuel economy from the costs of the fossil fuel economy. And what that means is that the fossil fuel industry as a whole appears hugely profitable, and governments and investors make decisions on that basis because the industry is not paying the true cost of its products. And we're ignoring the fact that these same companies play a major role in the floods, wildfires, sea level rise, and other climate disasters that communities around the world are having to deal with. The polluter pays principle is about the idea that we need to bring those costs together. It's about the idea that when society and the economy has the true costs of an activity reflected in the price that is being paid, that we make very different business decisions than compared to when those costs can be externalized and paid for by the public. And we make better decisions as a result. Transitioning to a climate-friendly economy is going to be a whole lot easier if the true cost is reflected in the costs of fossil fuels. We need governments and investors to make decisions based on this broader variety, and our cities need the resources to prepare for climate change, to respond to the impacts and deal with the losses that come from a polluter pays approach. Litigation, of course, is a major way of achieving that, but not necessarily the only one. By and large, in a climate campaigning context, the public messaging has centered around individual responsibility until relatively recently. I sometimes say that the message that the public hears from the environmental community has traditionally been turn off your lights and give money to Greenpeace, and somehow this problem will go away. The fossil fuel industry wholeheartedly endorses that approach, focusing on individual responsibility, because it allows them to continue producing fossil fuels while at the same time appearing to do something about the problem. The phrase carbon footprint was actually popularized by an advertising campaign from BP, the UK petroleum company. And just recently, Shell Canada has been reassuring its customers that we can continue to buy gas guilt-free as long as we pay an extra 2 cents per liter for offsets. So absolutely, individuals do have a role in dealing with climate change. We all have to do what we can. But turning off lights and taking the bus and riding our bikes only take us so far. So the thing that really concerns me about this, I mean, there's lots of reasons this concerns me, but one reason is if you keep telling people we're in a global crisis, the world is heating, we need to transform the way our economy works, and here's the solution, you need to turn off your light. This creates a big disconnect for people. It invites conspiracy theories and climate denial, And at the same time, and among the people who don't want to accept that, and a sense of hopelessness among people who do. It's also a recipe for accusations of hypocrisy against anybody who calls for climate action, but is still living in a world which is really structured around fossil fuels. A serious public conversation about the idea that the fossil fuel industry has some moral culpability for this issue does not really show up in a big way in the climate movement until the divestment movement, which really started in about 2010, so only a decade ago. This was the first movement to really begin saying that making massive public profits selling a product that you know will destroy the planet is morally wrong and not something that a responsible company or investor would do. And the fact that we're having a conversation today about the idea that maybe these companies should be paying a share of those costs associated with what their products do owes a lot to that initial work by the divestment movement and other movements that came after it to really shine a light on the so-called right of this industry to produce a product. Now, it's not an either-or conversation. Individuals do have responsibility to do what we can, but the fossil fuel industry and their investors also have a responsibility to do what they can. So when we ask Canadians what they think about who's responsible for causing climate change, Canadians have mixed views, but about 42% of Canadians think that the companies that produce, transport, and burn fossil fuel companies are most responsible for causing climate change. This is eco-analytics work done, I think it was in 2017 or 2018. They also found that only about 16% think that individuals who use those products are primarily responsible for, or most responsible for causing climate change. Similarly, when we start asking who should pay for the cost of climate change, individuals are very low, about 9%. Fossil fuel corporations and the companies that sort of produce these products are up there. About a third of Canadians feel that they should be primarily responsible for paying for the financial costs of climate change. Interestingly enough, I want to highlight the all of the above or some combination answer, because this is a phone poll, and this was not actually one of the options that people were given. So despite not being asked, do you think all of the above or some combination, 21% went out of their way to refuse to answer, to choose between corporations, governments, and individual citizens, and to instead choose that really it is about everyone doing their share. I think that's important. And we know from our own research, this is from a Google survey last April, that if you talk about the responsibility of the fossil fuel industry, not to pay everything, not to be primarily responsible, but to pay a share of the cost of climate change, there's a very high level of public support for that. We took this poll primarily to see whether things had changed during COVID. And in fact, the answers we'd been seeing prior to the pandemic were about 10% higher. But even now, significantly over 60% of British Columbians agree that fossil fuel companies should pay a fair share of the cost of climate change. And almost half, basically half, support the idea of suing them to ensure that that happens. And conversely, very low, relatively low levels of opposition, just under 20% for the basic idea, and just a little bit more than 20% opposition for those who to the idea of suing fossil fuel companies. So, but nonetheless, despite this high level of public support, when the resort municipality of Whistler dared to send a letter to a fossil fuel company. This wasn't litigation. This was sending a letter suggesting that that a fossil fuel company might pay a share of the cost of climate change. They experienced severe backlash, major accusations of hypocrisy. And so why did this occur if this public support is out there? Well, I think the main reason is that it focused on one of the letters they sent, and it's partly about the wording of the letter, but also a large extent about the media coverage, made it appear that Whistler was asking one Canadian company to pay 100% of the cost of climate change. And it did not recognize, or the letter did not appear to recognize as it was covered, that Whistler had any responsibility for that. This was, I think, largely untrue and certainly a misrepresentation of the situation. But the story is a cautionary tale about the importance of making it clear that we're talking about joint responsibility. The fact is, right now, taxpayers are paying essentially 100% of the cost of dealing with these impacts, but the fossil fuel industry is paying none of it, well, despite making massive profits. And so the narrative has to be about everyone taking responsibility, both for their role in reducing greenhouse gas emissions and for their role of dealing with the costs. Turning over to the more of the legal analysis, the starting point has to be Rick Heady's work, which was absolutely pivotal in terms of just demonstrating that 90 entities were responsible for almost 2/3 of human-caused greenhouse gas emissions in the atmosphere when he first published it. Rick's work allows us to break down those emissions, not just in terms of those totals, but by individual companies. And it allows us to break it down in different ways and have a conversation, begin a conversation about what is the fair share of each of these companies. So we can say from his work that Exxon Mobil, better known as Esso in Canada, is responsible for about 0.35% of the greenhouse gases in the emissions today from their direct emissions, from the emissions they actually produced in extracting oil and gas from the ground. If they pay, if they pay for emissions associated with their products, that's another 2.9% of human-caused greenhouse gas emissions, which gets us to a total of 3.2%. So we can begin that conversation as, does it make sense for a company that extracts oil and gas and processes and makes it available to the public, knowing that that will cause climate change? Does it make sense that they should pay a portion of that 2.9%? Should they pay all of it? Should they pay some of it? Should they pay only from the point at which they knew that their products were causing these impacts? Rick mentioned 1965 as a date that he's used. 1968 is a date that the American Petroleum Institute, which Exxon was a member of, received a major report that went really into the detail of the climate science and the impacts would be. Should we in fact not just be focusing on what they actually took out of the ground, but also what they refined and made available to customers, and what they in fact touched? We don't have figures for that because Rick's work focused very much on the extraction and production of fossil fuels. So, I mean, at this point, some people go, well, hang on a second, even if, I didn't mean to have these all time, even if the Chevron and Exxon and these companies are responsible for a lot of emissions, climate change occurs around the world. Can you really hold one company or a group of companies responsible for all of these different emissions occurring in countries around the world from all these different sources? And the fact is that the law has a lot of experience in dealing with pollution, and pollution is very often a multi-polluter situation, a situation where there are a whole range of causes. And generally the courts have said that it doesn't matter if you're a small contributor to a major problem, unless, and there's a whole body of law related to water pollution law that focuses on this question of, is the polluter significant enough that it can be sued? Not everyone can be sued. Clearly, you can't sue the world. How big does your contribution to pollution have to be before you can be sued? And what the courts have said in the water pollution context is if your contribution to the pollution is detectable, if there is, even through scientific instruments, if you can detect the contribution, you're big enough that you can be sued. Now, scientists can measure changes in the global composition of carbon dioxide down to about 0.1 parts per million. And the emissions of Exxon and the other major fossil fuel companies, even the direct emissions, let alone the emissions from their products, have caused well above that increase in the concentrations of carbon dioxide in the atmosphere. So they are significant contributors if you apply this test for water, from water law and water pollution law to the global atmospheric, the climate crisis. But often when we talk about these lawsuits, people will say, well, you're going to sue me for driving down the street? You can't sue everybody. And no, you can't. If your emissions are not globally detectable, you probably shouldn't be sued. My contribution is not that large, nor is yours. Chevron and Exxon's are. So that gets us into the question of how might a court go about apportioning liability if these companies were held liable? And the usual rule in BC law is joint and several liability. Joint liability means that one defendant is on the hook for all of the harm caused. They can then seek to recover that their co-defendants. But they are actually on the hook for 100% until they're able to get that back on a more prorated basis from their co-defendants. There's also several liability, which is where the court can actually divide up the injury and say each defendant should pay their own portion of the harm. This joint liability can be a little harsh on the defendant, for the defendant. But the theory is that it's even more unfair for the plaintiff, who really hasn't caused their problem and is going to the significant expense of trying to recover the costs from the defendants. But it seems more troubling in a climate change context. Exxon may be a significant cause of climate change, but we do all play a role in the fossil fuel economy. And it intuitively seems a stretch to say that they should pay 100% of the costs, even if they could theoretically recover those from other defendants. Several liability usually occurs where, as I say, there's this ability to divide the injury up. And that's the case where it might seem that is the, it might seem that climate change is by definition, the definition of an indivisible injury, one that can't be divided up. But interestingly enough, UK and US courts have generally held that an injury that's caused by cumulative exposure to a thing over time can be divisible when each plaintiff has contributed an amount that forms a portion of that. There's several other legal principles that lead me to believe that courts will probably come down on the side of a several liability approach to a lot of the injuries. Yeah, there's a quote from one of the cases. So the approach that I think ultimately is most likely to be taken by the courts is actually a sort of joint approach. I think that there may be joint liability between fossil fuel producers and the companies and individuals that burnt their product, that actually use the product at the end of the day. As between different fossil fuel producers, we're likely to see several liability and some variant of it. I know I'm probably tight for time. So I just did want to touch on a question that was raised in last week's webinar. And that's the question of whether litigation against fossil fuel companies advances issues of global fairness and global apportionment of costs and payment for costs. In other words, how can we make sure that fossil fuel companies, as well as maybe some of us in the north that have contributed more to develop to the fossil fuel economy, how can we make sure that those companies pay a fair share of costs in Vanuatu and Bangladesh and other countries that are climate impacted but have done little to cause the problem? And at a theoretical level, climate litigation can address some of those issues. At a practical level, it takes resources to bring these cases. It takes judicial capacity in the countries that are hearing the cases. It's way easier to collect those harm on the damages award if you have those countries actually in your jurisdiction, in your country. So I just like to make the point that litigation is one solution to this problem. There's also calls for the fossil fuel producers to be paying their fair share through the global climate negotiations and through legislation that is implemented at a domestic level, but which provides for cooperation between jurisdictions to ensure that money goes where it's most needed. So I think we can have these conversations about fair share and try to, while also trying to recognize and address some of the limits of climate litigation. So thank you very much. I'd like to acknowledge our funders in terms of this work, as well as, again, the UBC for hosting tonight's event and the other partners for the webinar series.
And thank you so much, Andrew. We have a couple of minutes for questions directed at Andrew for clarification. As people think about that, I'd actually like to take Patrick Boyle's question and pose it to Andrew, because I think you might be in a good position to answer it. So Patrick asks, as a legal practitioner, I've experienced researching the law, but very little peer-reviewed articles from the scientific community. Do you have recommendations on how best to stay up to date? on the scientific literature? And what about the internal documents of the fossil fuel majors? Before you start, Andrew, I'll just repeat what Ben said earlier, that many of the internal documents are now being made publicly available by the UC San Francisco project that you mentioned in your presentation. So, Andrew.
I'm wishing I had a better answer immediately springing to mind. I mean, I think that there are the sort of online portal, like the one that Dan referred us to, and he also mentioned the Center for International Environmental Law, which has done a lot of work in terms of summarizing some of the US work on this. I'm not sure that there is one go-to place. There was, I'm not even sure it's still going. The Climate Liability News for a while was doing a great job at recording some of the things. Oh, and then in terms of litigation, climate litigation internationally, the Sabine Center out of Columbia, the Columbia University,
yep.
has a database of existing climate litigation, including litigation against fossil fuel companies. So that might be a resource that people would want to look at.
That relates to the internal documents and the status of climate litigation. I think you'd also probably say that it's hard to necessarily point to one particular source for the latest scientific literature.
Yeah,
but the leading, science magazines like Nature and Science on their websites are good sources, and they have specific sort of, what do you call it, areas or sub-publications for climate science.
West Coast Environmental Law has recently hired our own climate scientists to help us keep up with that work. And so hopefully our blog may be a place where you can come to for some of that information as Dr. Sylvie Harder of our office publishes blog posts in the future.
There's one other specific question for Andrew. It's from Natalie Oman again, and she just asks, can you briefly recap your hunch about which approach you think courts are most likely to take to joint and several liability?
I mean, one of the problems of a 15-minute webinar is that you can only go so far in the weeds and still cover everything you want to cover. But in brief, I think that there's this question about the responsibility of a fossil fuel company for what they produce is what happens to their product and the end user. And I think when we're talking about the same oil and gas eventually entering the atmosphere, there's a case for joint liability. The idea that the company may ultimately not be responsible for 100%, but nonetheless, you should be able to collect 100% against the original producer. They may have to look at whether they could then recover something from their customers. That's a fundamentally different situation from where Exxon's taken a certain amount out of of oil and gas out of the ground, and Chevron's taken another amount, and different amounts of oil and gas are being burnt and ending up in the atmosphere. That is severable, or divisible rather, and therefore I think a several liability approach is likely in those cases.
Thank you, Andrew. Listen, we've got some other excellent questions in the queue, which we will hold until the general Q&A. So the question about Rick Heady's work in the courts, the question about the auto industry, the question about state-owned enterprises, and about greenwashing. So let's hold on to those, but I want to introduce our final speaker. A lot of the perceptions and the assessments around accountability and burden sharing have a substantial psychological element to them, both social psychology and individual. And I want to introduce Rob Gifford to speak along those lines. Rob is an environmental psychologist, a professor of psychology at the University of Victoria. Professor of Psychology and Environmental Studies at UVic. He's a fellow of the American Psychological Association, the Canadian Psychological Association, the Association for Psychological Science, the International Association of Applied Psychology, and he was recently inducted into the Royal Society of Canada. He's the author of 150 refereed publications and book chapters. Us lawyers can only look at those numbers with envy. 5 editions of Environmental Psychology Principles and Practice, and the editor of Research Methods for Environmental Psychology. And he also served as the chief editor of the journal Environmental Psychology for 14 years. So welcome, Rob, and please go ahead.
Okay, let's see if I can share screen here. So let's go. Where are we here? So, can you hear me? I guess you can hear me or no?
Yes.
You can, okay, sorry. So yeah, thank you for inviting me, Stephen and Andrew. I do, to be perfectly honest, feel like a bit of an outsider here. Well, I am a bit of an outsider. I'm not a lawyer. I don't know anything about law. My son is a lawyer, if that helps. And so on the other hand, at one stage when I was invited, I said I had cold feet about doing it. I didn't know if I had anything to offer really to a mainly legal audience. But I thought about it in another sense. You see these climate sector diagrams, you know, which sector has the most impact. And so you get something like for diet, should we only include the farmers and ranchers for diet, or should we include people who transport? So I've taken that to heart and sort of thought, well, maybe there is a role for environmental psychology in this discussion. I hope so. And I'm going to start off by saying something radical, but it's not only me. If you've heard of this amazing book called Sapiens, this guy, I forget his exact name now, but I think it's a book that's well worth reading, says we tend to think of companies and organizations and cities and municipalities as entities. And of course, they do have some legal status as persons, as I understand it, but really they don't exist. Exxon does not exist. It's a bunch of people who've decided to cooperate to make money from oil. The municipality of Victoria doesn't exist. It's a city council that represents some entity called the City of Victoria, etc. So that's where I'm coming from. I am a champion of the view that we're all individuals in this, and that we're important in that sense. So I hope that my comments will be complementary to those of Andrew, who seems to take a bit of a jaundiced view of the role of individuals, and that we can all work together on this. But also, I'm also going to criticize individuals as well. But I first wanted to confess my ignorance. I thought, laws, legislation requires social license as a kind of educated layperson, and if not, trouble will follow. But I wanted to recommend, because I wanted to educate myself a little bit, I found this wonderful looking publication that goes way farther than I knew existed into what is social license, different models of it, different measures of it, and whatever. So I just tossed that out. It's not really part of my talk, except it's part of my education in preparing for this talk. So we know that climate problems are caused by all these things in different ways. We all want to have good heat where we live. We know that capitalism is a problem. We know that technology is very enticing. We know that there are infrastructure problems that prevent us as individuals from doing things. And I learned in setting up something called the Human Dimensions of Climate Change program here at the University of Victoria, when I heard some lawyers speaking about how difficult it is sometimes to get legislation passed, apart from left-right, just the difficulties of the mechanics of it. So, but, the mantra around my lab and my area of psychology is that really it's about us, that citizens, whether you're an average person, whether you're a CEO, whether you're a legislator, whether you're a beer drinker, whether you're a driver, whether you're a gas jockey, whether you're a driver, these are all people. These are all humans, whether they're the CEO of Exxon or me. So we all make these choices every day. These add up enormously, as we know. I hope this is usually correct, that governments usually lead by social license, whatever it is. And that means, so what is social license? In some sense, it's got to be me and you adding up and voting. And industry, Exxon would die if we didn't buy gas. And you can say we sort of have to buy gas or whatever, but really we go there and we put our, I do too, go there and put it in our cars, those of us who have not yet gone electric. So one of my colleagues says that really there's no environmental problems, there's only human problems. I might change that a wee bit to say there are only individual problems. So we're not managing our emissions very well yet. And why are we not doing that from my perspective? This is a kind of a complicated model where we put governance context up at the top, but really when you look down to our choices in red there's a lot of things that go into it from a psychologist's perspective. Other people, our motives, technology, education, and of course our choices have outcomes for the resource itself and for ourselves, for society, etc. So we've learned in psychology that pure information is not a very good way to change all those individuals. Persuasion helps a little bit. Please don't work very well. Incentives work only a little bit. Even people who strongly believe in climate positive actions don't always do what they're supposed to do. So for us in environmental psychology, that's the key question. Why the heck is that? Well, part of it goes back to the science fiction writer, which younger people anyway older people seem to know about. Robert Heinlein wrote way back 50 years ago that man in old-fashioned language is not rational, he is a rationalizer. So we all rationalize a lot of things, and that's the key thing for this environmental psychologist, how we rationalize our choices that have to do with the climate. So that means we don't do everything that we should, not even we ourselves probably in this seminar think we should do. And the answer is what I call the dragons of inaction. I like to say it took me a long time to find a dragon and tape him, but we won't go there right now. So I also have this other model, a little simpler model that says, you know, why do people make their choices? If you see at the right end of my model there. Well, the standard model in psychology is because we have certain intentions to do things. And those intentions are influenced by the principles that we have, by social factors, and by simply wanting to do certain things. And of course, sometimes we're stopped. Our intentions are stopped by structural barriers. You know, there's no bike lanes, there's no buses in my town, etc. But what I've been focusing on for the last 10 years or so are psychological barriers. And that is the dragons that stop us from turning our intentions into choices. So I've been collecting, I collect a few other things, but I've been collecting dragons lately. And dragons basically are the excuses that we use, the rationalizations, the justifications that we use. And I have now collected over 10 years, something like 40 species of dragons and organized them into these categories, which I'm not going to go into in great detail. As you can see at the bottom, you can go see them if you're interested, either in my American Psychologist article or at my website there, The Dragons of Inaction. But they fall into these categories of not thinking very well, being influenced by certain ideologies, being pushed by other people, whether it's a boss or a partner, financial and other kinds of investments, mistrust of government and scientists, feeling like it's going to be risky to ride my bike. I've broken my arm twice now riding my bike, or just saying I recycle, so I guess I've done my part. And so I'm not going to talk about each one. I'll give you a few seconds just to glance through some of the limited cognition ones, because we just have 15 minutes or so now. Some of the ideologies that we've talked about that hinder climate positive action, how other people and media choices play a role in allowing us to not do what we ought to do, sunk costs, the economic concept. If I own a car, why should I take the bus? And we all have other things to do, believe it or not. So conflicting goals and aspirations is so common that I've given it an acronym. I just call it CGA now when I'm talking usually. And we're afraid of doing things for different social reasons, being teased, or whether it's going to work or not, or whether it's going to take a lot of our time, etc. And certainly some of us, not in this audience, I don't think, have reactance or straight out denial, or have the kind of personality that's against whatever, or just think that whatever program is offered is just not good enough to entice me. And then there's that limited behavior part of tokenism, or the rebound effect of I recycle, so I guess I should, buy a new Cadillac now to compensate myself. So it's sort of like, well, what can we do then, given that many of us use a lot of these rationalizations to avoid doing everything that we could do? Well, I like to think that in behavioral science and environmental psychology, we do have some skills that could be used that we think we possess. We're good at messaging. Sometimes some messaging experts are used to sell gasoline, as we know from this seminar, but we're also good at developing messages to go in the right direction. There's about 22 different messaging strategies being investigated right now by people like me in my world. We also think that we're good at designing interventions. If we do this, will it work or will it not work? And we're also, we think, good at evaluating interventions. Not all work very well. You might remember the 1-ton challenge was pretty much a failure. And so we like to think that we can design inventions, and that we can evaluate them, and that we can design messages that might work. So my kind of sum up is in this Rubik's Cube here, which I had the great honor to present to the Minister of Environment last April in Ottawa. To accelerate climate positive action, we have to understand different segments of the population. Not everybody's the same. Old people, teenagers, poor people, rich people, CEOs, lawyers, legislators, beer drinkers, we're all a little different. And each one of those is probably engaging in different kinds of behavior. Some people fly more, some people eat more meat, some people heat their houses more and buy mega houses. And those different segments have different dragons that need to be attacked. Not everybody's afflicted by the same kinds of dragons. So I will kind of conclude, I guess, by saying, I think we would all agree, especially I hope everybody would agree, that polluter pays. Polluters should pay. I would say, who are the polluters? The polluters are Exxon, which doesn't really exist. The polluters is me, and polluters is you, and polluters are all those other people. And let me say, when we say that each of us doesn't really matter, which is one of the chief dragons, is I don't have any control because I'm only one person. Perceived lack of control is what we call it. Let me conclude by saying there's a lot more of us on the planet than there is of them. And it's more a matter of us organizing against them, because there's a lot more of us than there is of them. So I will conclude with that remark and say, thank you very much for listening.
Thank you very much, Rob. I see that there is at least one question in the queue that I think is directed toward you specifically. And we have time for a couple of questions that are specifically for Rob before then opening up more broadly. So the question I see is from Karis Campus, and it says, I find it hard to understand the theory of individual choice for the average person when the entire infrastructure of society is designed around fossil fuels. The idea of choice is also made difficult by corporate disinformation campaigns. So the question is there a relationship between the structural and the psychological barriers to action?
Well, it's a struggle, isn't it, between the power of advertising on the part of Exxon or Walmart or whatever, and the power that we have to choose a lot of times anyway, where we go. If we don't like a particular retailer, we can go to another one. If we really don't want to drive a diesel power, I used to have a diesel powered Mercedes, actually an old one. We can choose an electric car, we can choose a bike. Now, I totally agree that we don't have full choice, but that we all can make more positive choices than we are now.
And let's just see if, I don't see another one coming in directly for Rob. So what I would like to do is now switch to more open Q&A session. We have around 20 minutes before our hard stop time. We already have several questions that have been posed. And I want to suggest a couple of them and just see who would like to handle them, if anyone. One of them is about the state-owned enterprises. So this is from anonymous attendee. And it asks whether we have a theory on why we're not seeing more climate litigation against state-owned enterprises, seeming a glaring omission considering that they may be accountable for 40 to 60% of global GHG emissions. Anyone want to handle that? Andrew?
I mean, I think that that's a great question. I think you're right that ultimately, if we just get liability of the private companies and not of state-owned companies, that's a significant problem. I think the assumption often is that somehow the state-owned companies have a bit of immunity. That's not legally the case in Canada. I don't know how it plays out in the U.S., but it is. I think that there's just a bit of discomfort that maybe a court will see that will treat this more as a government actor rather than a private company. In my view, that's actually not a barrier to suing in Canada when you're suing a corporate entity that's happens to be owned, that's carrying on a corporate activity. The other problem there is collecting. If you were successful in winning a damages order against these companies, how likely would we be able to collect against Gazprom or Saudi Aramco or one of these state-owned companies? And that, I think, is, from a legal point of view, going to be difficult. There was one of the Saudi Aramco subsidiaries was named in at least one U.S. Case. So it's not that there's been no effort to do that, but it was specifically a US-based subsidiary, and so that company was actually present in the country. It'd be difficult, much more difficult, I think, if to figure out how to collect if it was if you didn't have that company having a direct connection to, and operations in your country.
Yeah, and just to follow up on that, and those are all things that I think are really relevant. There's also less known about the activities in the history of many of the state-owned companies compared to the private ones. And the history of malfeasance and bad behavior plays a central role in these lawsuits. So, in addition to the issues over jurisdiction, and at least in the United States, how is a suit against a state-owned oil company going to bear on international comedy? That's a consideration, I think. And then in addition to those things, there's also less known. Now, hopefully that knowledge gap will be filled, in the years to come, sooner rather than later. But it's a great question.
There's actually a really quick follow-up question that I think goes straight to this same point, which is what about, and this is from Karis again, what about state investors? So like Export Development Canada, Any thoughts on that, Andrew or Ben?
I'll take a crack at it. You know, this is something I'm less familiar with. I actually was a plaintiff in a suit about fossil fuel investments many years ago when I was a student at Harvard. And it was a very novel lawsuit, and we sued Harvard University for its investments in fossil fuels. And that was dismissed on standing issues. But, you know, the creative legal approaches for investors and holding investors to account when it comes to climate change, I think are quite important. And, you know, I think it'll depend on the kind of investor as well. Nonprofit entities have different social responsibilities and legal obligations than other entities do. So, you know, to my knowledge, there's been not as much action on that front, but, you know, I think it's reasonable to consider actions in that direction.
I think that in terms of public investment, you know, some of the arguments that we generally have, certainly in this webinar series, have made a distinction between lawsuits against private companies and the lawsuits against government that raise maybe more constitutional issues. You know, when it's a public body doing the investment, that kind of may blur some of the lines between those two types of litigation, and there may be the potential to raise some more constitutional issues in relation to the investment decisions. I'm not sure I have a clear answer beyond that.
Yeah, and another idea, just thinking out loud a little bit, is that, you know, at least in the Netherlands, there is an injunction, again, you know, addressed to the national government there to make policies that conform to the Paris Climate Agreement. And so, you know, I think there's a lot of uncertainty about how an injunction against a national government issued by a court is going to be enforced. It's obviously going to vary between jurisdiction to jurisdiction, but if there are state investments that are clearly out of alignment with that, then that could be an avenue for, you know, for enforcing such an injunction.
Now, I would just add that the question is taking us a little bit in a different direction than this particular webinar is focused on. Well, in fact, the whole series of webinars really, as Andrew mentioned, focuses on the prospects for seeking accountability from fossil fuel producers. But the question about the export development banks or the various, you know, government public finance institutions takes us into a different possible direction, which is looking at accountability of the financiers. And that's a really important issue, but it's probably, I don't think we're in a position to really address it head on because of the focus of this set of webinars. That said, I think it is a very important question, whether it's private finance or public finance. It's a big part of the equation here. But I would like to shift gears slightly. Andrew wanted to pose a question to Robert Gifford. So Andrew, go ahead.
Yeah, Robert, thanks for your presentation and for doing this. I guess first, just a brief comment. I think I don't think that I actually do downplay the importance of individuals as much as you suggest, or maybe that I came across as suggesting. But and I think some of what we're ultimately talking about is the role of institutions in society in psychological decisions. I guess I wondered, but in terms of the question, I specifically, a lot of the dragons I think relate to, or some of the dragons seem to relate to sort of not seeing the effect of one's actions and not having things be perceived as affecting you. Does the shift from talking less about how do we tackle climate change and more to the practical question about how do we protect our communities from climate change and how do we pay for that? Does that affect any of the dragons and how they interact with it at the individual psychological level?
I'm sorry if maybe we're talking across disciplines here a little bit, but how does what affect dragons?
Rather, most of the climate discussion focuses on how do we stop this global problem.
Yeah.
And I think some of the dragons relate to sort of the distance away from people and the lack of what that means for their lives. When you're talking about how do we pay for this, it's about the fact that Metro Vancouver municipalities need to come up with $9.5 billion to deal with rising sea levels between now and 2100, according to the province of BC. It's about the cost of like, how do we build our communities in ways that are wildfire resilient? And how do we rebuild after if they are destroyed from wildfires? Does that focus on sort of the hyper-local costs and impacts change how the dragons interact or work rather?
Gee, I wish I had a better answer to that, but I almost feel like it's you know, we're on two sides of a bridge and the bridge isn't totally built there. I mean, intellectually, I mean, but my first thought is, well, we're all taxpayers. That means we're all voters, which means we can all elect the right, you know, if we vote the right way, we can elect governments that try to change who pays for what. So I see it as a, you know, again, collective action, organizing, almost like a early union days of organizing to hire the governments that will do the right thing in terms of who pays. But of course, I guess we're all, you know, given that we're taxpayers, we ultimately are paying, but we don't have a choice of how much to pay. Although back in the 60s, I remember Joan Baez and other people just refused to pay their taxes. I mean, there is that option, I guess. But I don't know if I'm connecting with you or not, but I think organize to elect the right government and then things will fall into place from there in terms of paying.
Yeah, no, but I guess I'm maybe the question's less about the paying aspect and more about that sense of distance that seems to be at the root of some of the dragons. If we're not talking about polar bears and Pacific Islanders, but we're talking about how do we build our seawall differently or deal with the fact that communities in BC had to evacuate in 2017. How does that help us in terms of advancing that organizing?
Okay, sorry to misunderstand. No, absolutely. I talked about messaging strategies and how to frame messages. And one of the cardinal rules that we've learned from a lot of empirical research is that the message should refer to, as much as, you know, truthfully possible, what's going on in your backyard, not what's going on in Uruguay or with polar bears. People respond much more to hearing the, you know, the smoke that we had in Vancouver and Victoria than they do to, you know, some damage far away. So localizing climate change is one of the key pathways toward activating people.
Can I ask
and on the other side of it, the more that you popularize polar bears, the more people turn away from the issue. People don't really care about polar bears. They care about smoke in their lungs.
Can I ask a follow-up question to you, Rob? So you showed the Rubik's Cube slide, and you said you had presented to the Federal Environment Minister. So I've never solved a Rubik's Cube. I find them extremely intimidating, but I'm wondering, and it had those 3 different dimensions in the cube. What message did you convey to the minister? And like, how do you convey all of this very complex research and insight to a politician in whatever 5 minutes you have with them?
Well, I don't want to brag, but I had an entire day and gave 5 different presentations to him and his ADMs and his staff, and everything. Was an entire day of presentation. But I will say that I believe in the Rubik's Cube. I do understand that it's very difficult. And I will also say that I have had some, what can you call it, callback from his staff. But I also think that the minister probably was hoping for one silver bullet message for everybody. And, you know, they don't want to, you know, they could, but they don't seem too keen to have one message for Newfoundlanders and one for Albertans and one for Quebecers and one for BC people. They would like to have one message. So I think they were probably a little bit not happy with my talk, or if you want to put it that way. But I felt like I was telling the truth, and there's no doubt that you want to talk to a grandparent, talk to them about their grandchildren. If you want to talk to somebody who's trying to make money in the stock market, you talk about money. I mean, really, it's pretty obvious, I think. There is no one message.
Mm-hmm.
So I don't know what to tell, you know, what to tell them, you know, except the truth as I see it.
Yeah. Thanks. I'd like to go back to the question queue. There was a question from Christy McLeod. Hello, Christy. Who asks how Canada's climate plan should interact with the Canadian carbon majors. In other words, large oil and gas companies headquartered in Canada. So should we be enacting legislation to require them to reduce their emissions in line with a definition of fairness, or some other ideas on how governments can regulate unfettered emission growth? Any thoughts about that? It's a little bit similar to the question earlier about what a Biden administration might or should do, but in the Canadian context.
So the carbon majors that are headquartered in Canada are globally significant in terms of their contribution. I mean, all of the carbon majors are, but they are much, much, much smaller in terms of their historic emissions than any of the sort of biggest of the carbon majors. So when we've talked about suing fossil fuel companies, we actually generally have recommended going after the largest companies, and then occasionally said, well, maybe we should throw a Canadian company in there just to see what that, you know, how that would work. The emissions from the carbon majors, because they count the emissions from their products, are about downstream emissions rather than the emissions occurring in Canada necessarily, although some of them obviously would occur in Canada. I think conversely, there's emissions that occur in Canada that are from carbon majors that aren't based in Canada. So in some ways, the conversation has been separate, and maybe that's a mistake. There was a proposal for legislation out of a group in Oregon that called for the idea of climate risk bonds. And this was the idea that every jurisdiction should pass legislation saying that when an oil and gas project or a coal mine or whatever, you know, a fossil fuel project was going ahead, the company responsible should post a bond for the climate damage their products would cause in a way very similar to mine, you know, what mines have to post for cleanup costs and other environmental harm. And so the idea would be basically that Canada would require companies to look at what the impacts of the climate impacts of their oil and gas would be, and then post money up front, post a bond up front. And if that damage materialized, it would then be part of what could be used to pay for dealing with that harm. I think it's an interesting idea. And what they did to get around the problem with that is you're only regulating your own industry. And you're increasing a cost on Canadian industry, while industry around the world is then sort of off the hook. One of the advantages to litigation is you can sue these global companies for their global emissions, but do it from within Canada. What the authors of that report suggested was that each country enter into a reciprocal arrangement when they pass this legislation, so that if they suffered harm, they could actually access some of these risk bonds from other jurisdictions. And conversely, if the harm occurred elsewhere, the Canadian bonds could be made available to help with the harm elsewhere. It's a fairly complicated process, and it's not one that we've necessarily been pushing for, although interestingly enough, the BC government did actually make some commitments to something along those lines in the most recent provincial election. I'm not sure that directly relates to the climate plan. I think that the Canadian climate plan has been focused on direct emissions rather than indirect emissions. You can't meet Canada's climate targets if you don't severely reduce the amount of emissions coming from the oil and gas industry, just because it's such a large portion of our emissions and it's a growing portion of our emissions. So it certainly has to be tackled, but whether it's tackled because they're the oil and gas industry, or I don't see the advantage to tackling it because they are carbon majors per se. I think that there is a question of whether Canada's plan or provincial legislation could actually clarify some of the liability for these companies under Canadian law. That's an important topic, but there's been no signals from the federal government that that's part of Canada's climate plan so far.
I'm going to pose the final question to Ben. There are just 2 questions in the queue. They're both addressed to Ben, but I think out of fairness, we should take the earlier one, which was posed almost an hour ago, and that was from Dan Galpern, and it comes back to this issue of greenwashing. Is there a difference between the greenwashing that aims to bolster reputations of carbon majors by exaggerating their investments in renewables and brainwashing about the impact of emissions stemming from their main products? So isn't that different? And if so, what would the implications be?
Thanks. I think they are different. They're different categories of activity. They both might be liable under, I'm thinking of unfair business practices statutes, which vary in their specific language and their case law from place to place. And, material misrepresentations regarding the company and what it's doing, regarding the products, what it's doing, regarding the impacts and the effects of the products. That third one essentially gets to the disinformation about climate science. But of course, the big model for a lot of this climate litigation is other cases of corporate cover-ups, especially tobacco litigation. So, there are different ways to apply the law to that set of historical facts. But yeah, I think that's right. They are different, at least, in terms of how you might address them. Now, if it's okay, I just want to quickly address that very last one, because I think it's a really interesting question of shareholder suits against the fossil fuel companies, what we sometimes call derivative suits. And typically one has to be a shareholder and say, hey, to the corporate manager, you didn't protect shareholder value and I lost out and I want, some money back or something. And as for going after them for disinformation, I think that might be difficult because there's a good argument that the companies actually serve their shareholders well while selling everyone else out. But one can look at, whether such suits were brought against the tobacco companies or others. I think suits against the fossil fuel companies saying you're not accurately disclosing the collapse in company value that you will see if you do conform to the Paris Agreement. If you change your business model to conform to climate goals, what's going to happen to your stock? And, I think there is a strong argument to be made that the companies are not accurately disclosing that. And that's my personal opinion from looking at some of their annual reports and the way they're treating the issue. And of course, that's what the New York State Attorney General case against Exxon was about. And that case failed. So that failed doesn't mean that others won't succeed, but that's a live issue. And then very finally, I put in some written answers in some of the already answered questions to supplement the other great answers. So in case that's helpful, but thank you.
And thank you, Ben. We're going to need to wrap things up here. I want to express my deep gratitude to our panelists, Ben Franta, Robert Gifford, and Andrew Gage, as well as our pre-recorded panelist, Rick Heedy. Remind you also that the recording of this webinar will be available on the Center for Law and the Environment at Allard School of Law website in the coming days, along with the original recording of the interview with Rick Heedy. And I just want to leave you with, this should be it, the information about next week's final seminar, Part 4, Putting It Together, Implications for Investors, Lenders, Insurers, Markets, Campaigners, and more. That will feature, it'll be moderated by Andrew Gage, and it'll feature Lindeen Patton of Earth and Water Group, Priyanka Vittal of Greenpeace Canada, Alex Bernhardt from MMC and Mercer, and Sharon Eubanks, the National Whistleblower Center. And although we weren't able to get to all of the questions today that the audience posed, we got to most of them. And one or two of them, including this question of in what position is the government of Canada now in relation to these questions, now that it is the owner of the Trans Mountain pipeline expansion project? So yes, questions like those we're going to address next week in the final webinar. So once again, thank you everybody. Thanks to the audience for joining us. Thanks to the panelists, and good day to you all.
Thank you. Bye.
Bye.